Hi friends. So I'm back with my series on DPDP Act 2023. Please note that this is not a legal advice and should be used only for reference and educational purposes. So what does the clause on withdrawal of consent says? It mentions that if a data principal withdraws her consent to the processing of personal data, the data fiduciary shall, within a reasonable time, cease and cause its data processors to cease processing the personal data of such data principal unless such processing without her consent is required or authorized under the provisions of this Act or the rules made thereunder or any other law for the time being in force. So what does the clause says? The clause says that upon withdrawal of the consent, data fiduciary shall cease processing of the data within reasonable time after withdrawal of consent by the data principal. Not only this, it shall also ensure that data processors cease processing the personal data of such data principal. So what it has to do? It has to inform the data processor also. Then, however, this particular clause also gives an exemption. It says that processing without consent can continue if it is required or authorized under the provisions of this Act or the rules made thereunder or under any other law for the time being in force in India. So friends, let me give you an example here. Say there is a data principal by the name of Alice. She signs up for a gym's fitness app. The gym collects Alice's personal data like her workout history and contact details. Now this gym has also appointed a third party company which we can say is the data processor that sends out workout reminders and promotional emails on behalf of the gym. Now Alice decides that she no longer wants the gym to use her personal data and therefore she withdraws the consent. So as soon as the consent is withdrawn, the data fiduciary, that is the gym, should stop processing of the data within reasonable time after withdrawal of consent by Alice. Not only this, it shall also ensure that the third party processor should also stop sending any reminders to Alice. However, suppose if Alice does not pay the membership, she has not paid the membership, then the gym may still continue to process the personal data of Alice in order to send payment reminders, as this is required under the financial regulations. However, the data processor will not send any marketing and promotional emails because that is not a requirement by any financial regulation. Now the Act further says that the data principal may give, manage or review or withdraw the consent to the data fiduciary through a data manager. Now the Act also defines that what is a consent manager. So consent manager is a single point of contact to enable data principal to give, manage, review and withdraw her consent through an accessible, transparent and interoperable platform. Now Arjun wants to use, say, a new financial management app called MoneyMate. Now before he starts using the app, he is introduced to an online dashboard managed by a consent manager named Raj. So what is this dashboard? This is an accessible, transparent and interoperable platform. So this dashboard allows Arjun to easily give permission to the app to access some financial data or to manage which third parties can access his data and revoke the permissions. So Raj ensures that this particular platform, the dashboard, is easily available to Arjun so that his preferences are adhered to and are not violated. So the consent manager shall be accountable to data principal and shall act on her behalf in such a manner and subject to such terms and conditions as may be prescribed by the board. Every consent manager has to be registered with the board in such a manner as may be prescribed. Consent manager may be subject to such technical, operational, financial and other conditions as may be prescribed. For example, to act as a consent manager, it may be prescribed that the consent manager should have secure data encryption. It should provide transparent data handling processes, maintain financial stability to ensure that it continues to offer secure and reliable services to the data principal. Now, what does the clause on consent is basis of processing mentions? It says that where a consent is given by the data principal is the basis of processing of personal data and a question arises in this regard in a proceeding, the data fiduciary shall be obliged to provide that a notice was given by her to the data principal and consent was given by such data principal to the data fiduciary in accordance with the provisions of this act and the rules made thereunder. So it mentions that suppose where their consent is the basis of processing, that is processing is done based on the consent received from data principal and a question arises about such basis of processing in a proceeding, in a legal proceeding. So the data fiduciary has to prove two things. It has to prove that adequate notice was given as required under the DPDP Act and it also has to provide logs to ensure that consent was given by the data principal. So friends, if you have liked my video, definitely like it, subscribe it and share across. Thank you. Thank you.